When it comes to creating an express trust, there are three certainties that have to be met: certainty of intention, certainty of subject matter, and a certainty of object. And in this three-part series, we're going to be looking at the three certainties, starting with the first one, which is certainty of intention. So without further ado, let's get started. When we think about the certainty of intention to create an express trust, perhaps the first question that springs to mind is, well, instead of what other type of instrument? And there are a number of alternatives available to people that we should be always aware of when answering either an exam question or a problem question. First of all, in Milroy and Lord, there was the discussion about gifts, and in particular, the court was keen to point out that a trust instrument cannot simply be used to perfect an imperfect gift. A charge, meanwhile, is quite similar to a trust in the sense that it allows a person access to a certain value from a fluctuating pool. But because it doesn't grant a person a right to a particular piece of property, it's distinguished from a trust. In Foley and Hill, the courts took the opportunity to discuss bank accounts. There was some thought that maybe this is an example of a trust, but the courts decided in the end, and this is possibly good policy, that when you pay money into a bank, you're essentially transferring it and there isn't a trust relationship in place. It's also important, and this is perhaps the most common one that will come up in problem questions, to distinguish between trusts and sham devices. In other words, where someone is trying to create a trust to avoid certain liabilities, as was the case in Midland Bank and Wyatt, where a husband transferred the home into his wife's name to avoid certain business liabilities. In such cases, Lord Justice Arden in Hitchenstone 2001 pointed out about the importance of examining all of the external evidence, including the context of the case, in order to distinguish between where a trust is genuinely created and where it's being used as a sham device to avoid liability. It is possible for the courts to infer that a trust exists, and so we can see, for example, in Paul and Constance 1977, the words that we used were, "The money is as much mine as it is yours," and this very simple language was deemed sufficient by the courts to establish a trust. Similarly, in Re Cayford 1975, there weren't any words spoken whatsoever, and instead the company created a separate bank account for certain monies, and that itself was deemed sufficient to establish a trust instrument. This can be contrasted with the Fairpack case from 2006. This was quite famous at the time because it involved a lot of people losing out on money around Christmas time because they had put money into a savings scheme, and then that company, Fairpack, had gone bust and the people had lost their money. Now, probably the courts in this instance should have applied the reasoning in Re Cayford and held that a trust relationship did exist, but they didn't follow this ruling, and arguably this was a wrong decision to do so. The creation of a separate bank account can be seen to infer a trust in existence. However, it's important that we also don't go too far with this. In Tito and Woodell number 2, the word trust, even if it's used, does not necessarily create a trust. And this is particularly important if we think back to sham devices as well. So just because someone calls something a trust doesn't necessarily mean that it isn't a sham device being used to avoid liabilities. We have to really examine the context of it and see if a trust does truly exist. We also have to distinguish between trusts and moral obligations. In Re Adams and Kensington Vestry, the words used "in full confidence" only imposed a moral obligation. But in Comiskey, the exact same words were used, "in full confidence," but in this context, they actually created rights for other people apart from the legal owner. And this was deemed sufficient to actually establish a trust. And this idea of creating rights for other people is really important and definitely something that you want to look out for. This was re-emphasised in Westdeutsche Landesbank Girra-Zentrale and Islington London Borough Council in 1996, which basically posed a similar question. Would it be unconscionable of the legal owner to deny others rights in the property? If the answer to that question is yes, it would be unconscionable for the legal owner to do that, then we can perhaps infer that a trust exists rather than a mere moral obligation. Finally, before we finish, we can look at wills, and we have to make sure that any will is established in a trust instrument. And there are a couple of things that we look at: the wording of the will itself, and we can look at Reed Denley as an example of the importance of the wording, and also the context of the trust creation as well. This comes back to the idea expressed earlier by Lord Justice Arden about examining all of the external evidence to try and work out if a trust has actually been created. And that takes us through the certainty of intention. Make sure that you subscribe to this YouTube channel so that you get updates when I do the other two videos on certainty of subject matter and certainty of object, as well as other videos on a range of legal topics that you might find interesting. If you enjoyed this video, make sure to leave it a like, and if you have any questions, then as always, leave those in the comments box below, and I'll try and get back to you as soon as I can. Thanks very much for watching. Bye!